have the natural theory of law. The natural theory of law is that theory that believes that law must be drawn from morals, ethics, moral rights, things that are naturally good, right? So, in fact, in this theory of law, there is a strong interlap between law and morality because they believe that whatever we call law should be morally right. This school of thought also believes that law is usually given by a higher being, a divine being. So you find persons who believe that everything that we call law is from a divine being like God, Allah, Krishna, or something like that. Persons, proponents of this school of thought are, you would find Aristotle in this school of thought. Thomas Aquinas is also here, and then John Finney. So they're about they are one of the proponents. They are the proponents of this school of thought. As far as they are concerned, any law that is morally wrong is an unjust law. Now, there are criticisms to this school of thought, right? Because then we ask ourselves, whose morals? Whose morals are we going to base our laws on? Is it going to be the morals of the atheist, or the morals of the Hinduists, or the Christians, or the Muslims? Whose morals are we going to be tailoring our laws after? So this is a strong criticism against it. Also, you find out that there are some things that ought to be law, even though that they are not morally right. Example, status of limitation. Okay, so we're talking about theories of law, right? You know that just as with the definition of law, there are so many definitions of law that you have. If you're a law student, you would have found out that there are so many definitions of law. So are there so many theories of law. There are so many schools of thought that see law as one thing and the other sees it as the other. So usually this is a topic you will find in legal methods, and then you also find it later on in jurisprudence. But in jurisprudence, you find it in a more deeper perspective. But in legal method, it's more or less the peripheral. So let's look at it from the beginning. Morality would make you believe that once you have a right, it should be your right in perpetuity. But status of limitation will come in and say, no, if you did not activate this right within so period of time, you've lost the right. And so you find out that morally, it may not really make sense, but it is a law. So let us go over to the next school of thought, which is positivism or positive theory of law. Positive theory of law believes that law must be in writing. Okay, so what we call law should be enacted by a constituted and valid authority. It is not just what you have in your head. It is not just what you believe that this thing is. It should be from a constituted authority before you can call it law. Otherwise, it is your thoughts, it is your opinion, it is your thinking. And this school of thought also believes that for a law to be valid, it should be enacted, just like I said. It should be in writing, and a valid authority should have enacted it. So whether it is morally right or wrong, it is no one's problem. Once a legitimate authority has enacted the law, it is a law. So John Austin falls under here, because he himself believes that law is a command of the commander, right? So because it comes from a valid authority or a legitimate authority, it is a law. There are other proponents of this school of thought, but the positive school of thought does not really believe in moral rights or stuff. Even if it is a moral right, has it been enacted by, or has it been adopted? Has it been propounded? Has it been enacted? Has it been accepted by a constituted and legitimate authority? If not, it is not yet law. Until that authority acknowledges, recognizes, and enforces that thing that you call moral right, then it becomes a law. Otherwise, it is not yet a law. So we have historical school of thought. Historical theory of law, we have historical theory of law. Historical theory of law believes that law must flow from the people's lived experiences. So you find out that if you go into a society that was plagued by coup d'etat, you will find out that some of their laws would tend to stand against coup d'etat, abolish it emphatically. If you go to countries that were plagued by slavery, you will see them making laws against slavery. And then you may not find that in countries that were not plagued by slavery. If you go to countries that were plagued by certain unique experiences, their laws may tend to speak against those things, or their law may also adopt those things. So historical school of thought believes that law does not come from the sky. The law that you and I know should include, should preserve, and should also be a mirror into the people's history. It didn't just fall from the sky. Frederick Savigny is one of the proponents of this school of thought, and he believes that the law should carry the people's spirit, right? Or what we can call the national spirit of law. The people's customs, traditions, lived experiences should be preserved or made louder or abolished by the law. The law of the people should be autochthonous, should be unique to them, because their experiences are unique. So customary law will also fall under here. One of the criticisms of this school of thought is that it may tend to preserve harmful practices since it is just tradition. So for the fact that it is a tradition, persons may tend to hold on to it, not for the fact that it is right or wrong. Another criticism is that this school of thought should be forward thinking and not remain backwards. So, but then you can always marry your past with your future and your present. So that is it. Now we have the next school of thought, and that is the sociological school of thought, or the sociological theory of law. And so we have this particular sociological school of thought believes that law should be used in society. It should be a functional thing. What we call functional art? That is an art that can be used to do so many things, right? Now, a law should be functional. It should be able to function in a society. It should be able to be a mirror into the current societal norms at the time. So you would find out that laws should be used as a form of social engineering to make the world better, to make the society better. If you are enacting laws and those laws do not tend to help the society, and so if you are enacting laws and those laws do not tend to heal the society, solve problems in the society, if they are too abstract and they don't solve pertinent problems in society, it is not a law per se. So laws should heal society, should solve problems in society. Roscoe Pound is also a proponent. Roscoe Pound is a proponent in this school of thought. So we'll have alternative dispute resolution as an ambit of this school of thought, family law, equity, some of these things that tend to help society become a better place, and then abolish survival of the fittest. Things that make, even consumer protection laws, things that make the world better will fall under this school of thought, because what they believe in is not just about being morally right, wrong, in writing, a command, your history. If it does not better the society, it should not qualify as a law. And so we're going to look at another school of thought. Now we have the realist school of thought, or the realist theory of law. These people are the ones who believe that the law should be real, it should be feelable. It is not just about what is in writing, it is what the court calls a law that is the law. To them, any law in action is a law. What is the law in paper? Okay, but what has this law become in practice, in real life? And so this school of thought believes that it is the judges that actually make the real law. It is the judges in court that make the real law. That is why it is a realist school of thought. So we find persons like Oliver Wendell Holmes here, who says that the prophecies of the courts are nothing more pretentious is what the law is. So he believes that even though the law may have defined a man and a woman to be something, what does the court define the man and a woman to be, right? Even though a law may have said what is who may win an election, but what has the court ruled as the grounds for winning an election, or the criterion for winning an election? Whatever the court says is the law is what this school of thought believes is the law. This school of thought is very, very subjective, because it rests on the ideologies of the particular judge. See you next time.